Hello, sir.
Yes, ma'am, I'm present there.
Yes, sir. Well, I'll start it now, sir. Okay, sir.
Sure.
Good morning, dear professors. Hope all are safe and healthy. I like to start the day with an inspiring note of John Wooden. Things work best for those who make the best of how things work out. Welcome you all to Pratisha family and for the day 3 of the Atal FDP on patent law for engineers and researchers. I like to introduce today's guest, Mr. Swapnil Sanap, who is an associate partner at Kurana and Kurana, advocates and IP attorneys and IPRB. Swapnil is a software engineer with a bachelor degree of engineering and master degree in information technology, and he has over 10 plus years of experience in IPR domain. And he is also a registered Indian patent agent and is legally allowed to represent upon authorization any applicant at Indian Patent Office. He has worked for Indian, US, Chinese, Australian, German, and Canadian clients for projects such as, but not limited to patent research, patent drafting, preparing responses to office actions, etc. He has also worked in domains like electronics, telecommunications, software, mechanical instrumentation, automobile, semiconductor, and electrical for patent research, drafting of patent application, and office action projects. His practice also includes patent drafting, office action response drafting, prior art searches, infringement analysis, clearance searches, and on project relating to sophisticated technologies ranging from electronics, computer sciences, IT, electronics and telecommunication, mechanical, biomedical devices, and business method domain. Swapnil is currently focused on product conceptualization, getting early adopters in firm, client acquisition, business development, building team, creating business system, business processes, and facilitating startup in West India jurisdiction for motivating and assisting them in filing various IPRs the best of their interest. Good morning, sir. Welcome to today's FDP, sir. The session is yours. Thank you, sir.
Thank you very much for brief introduction, ma'am, and I really appreciate inviting me for this wonderful session. And it's always inspiring to be a part of such sessions where engineers and faculty members and students are really interested to know about the IPR and the nitty-gritties about it. Let me just share my screen and let me know if it's visible to all. Is the screen visible to you, ma'am?
Yes, sir. Yes, sir.
Great, great. So, as ma'am has introduced, let me start with a very brief note about myself and my journey in terms of IPR. So basically, I am also a software engineer. I have done my bachelor's and master's in information technology, and it has been more than 10 years that I am working in this field of intellectual property rights, which is a completely different field as compared to the normal engineering processes or engineering, work that we do generally. So I also come from a technological background, and being IPR as a field of law, it has been very challenging for me to be a part of this field. But it is very, interesting, and it has been very good journey for me to be a part of this IPR domain for a long time now, and I look forward to be a part of it in future as well. So, like ma'am has mentioned, it has been more than 10 years that I'm working in this field, and I have tried to work on almost all the different types of work that we get to know in this field of IPR, not only from patents perspective, but from trademark, copyright, and other different fields of IPR that has been introduced to you in the previous sessions as well. So I have been closely working with individual inventors, R&D professionals, research scholars, PhD holders, for understanding their invention, understanding their projects, understanding their thesis, and then trying to suggest them in terms of what can be protected in the IPR and how we can proceed further with the processes thereof. So I am currently based in Pune, and I am the head of Pune office for Kurana and Kurana Advocates and IP Attorney. Basically, this firm is a law firm which deals only with the matters related to intellectual property rights. So with this note, let me start with this session. So the responsibility given to me for this particular session is giving a brief understanding about the life cycle of a patent application and specifically with the processes related thereof. So the session will have following contents, as you can see in the slide. Directly jumping
Sir,
onto the
excuse
life.
me, sir.
Yes, ma'am.
Excuse me, sir. The slide
Yes,
is
ma'am.
not visible, sir.
It's not visible.
No,
Okay.
sir. Yeah.
Let me just reshare it with you. Is it visible now? The screen is visible.
No, sir. It's coming and going, sir. It's not.
Now?
No, sir. No. Now, sir. Yes, sir. It's okay, sir.
Visible? Okay, great.
Yes, sir. So put it as a slideshow, sir. So it will be.
Sure, sure. In the meanwhile, while we are presenting, please let me know in case if the slide goes off and on, So I'll be
Yes,
just
sir.
making it easier. Yeah. So like I
Yes,
was
sir.
mentioning, today's session cover these basic points, and directly jumping onto the life cycle of patent application, I would prefer to briefly introduce to you what you may have already heard in the previous sessions from the various esteemed faculty or the presenters. What is a patent? What is an invention? I'll just give a touch base of it from the perspective of a techno-legal domain, and then I will go into, I'll try to dig into the details of life cycle of patent application, the requirements for filing a patent application, and the requirements for patent drafting in a very brief manner, because I'm sure the other presenters would go into details of each and everything. But being a part of a life cycle of a patent application, it's essential for us to understand the start and the end, and to close the loop of this particular cycle. So what is a patent? Basically, according to the patent laws, this patent is nothing but an exclusive right given to an applicant by a respective government for a limited period of time against the disclosure of the invention. So in very simple terms, basically patent is nothing but a right. It is a legal right given to you by a government. Respective government means any particular government of a jurisdiction where you have filed a patent application in. For example, if you file a patent application in India, then the Indian government is the responsible government or authority to grant you a patent during the process for it. Similarly, if you file an application outside India, for example, in United States or in Japan or in China, and the responsible government for them or for the respective jurisdiction. So Chinese government, Japanese government, or the USPTO, that is the United States Patent Office, the government thereof is responsible for granting a patent in those jurisdictions. Most important point to note here is that the patent is granted for a limited period of time and only against the disclosure of the invention. So this is very crucial, because when we discuss the life cycle of patent application and the requirements of filing a patent, these are few of the important criteria to decide whether a patent is to be granted for or not. In my real-time experience, I have faced many such issues where the inventors are hesitant to share or disclose the information about the invention in a detail, so that they ultimately end up not getting a patent granted for it. So most important point as per the definition of getting a patent granted in any country is that you file a patent application with sufficient information that is required for understanding and or implementing the invention by any person. For example, a person skilled in that particular area of technology, or a person who belongs to that particular technology. With this note, the rights that I was mentioning are the legal rights, and what legal rights the government gives you is basically the legal rights are associated with making, using, offering for sale, selling, or importing the patent invention. Most important point here it needs to be understood is that patent is a negative right. It's not a positive right. When I say negative right, it means that it prohibits others from doing these activities. It does not prohibit yourself or you one, right? So that is the reason why it is mentioned as patent is a negative right and not a positive right. So patent, when it is granted to a person or an applicant who has applied for it, he can stop others from making, using, offering for sale, selling, or importing your invention or whosoever the patent is granted for. What is an invention according to the Act? We have studied that patent is generally granted for inventions. Now, what is an invention? That also needs to be understood. If you go on internet and try to search what is an invention, you will get around thousands of definition, different types of definition for the invention. But according to the law, according to the patent law in IPR, invention means only these particular things. According to the law, patent law, invention is nothing but it can be a new product or process which involves an inventive step and capable of industrial application. We are going to just touch base on every particular definition of these things. I'm sure you must have already studied this or understood this in
Hello.
previous sessions.
Sir, excuse me, sir. So you're not moving the
Yes.
slide now, sir. You're only in the first slide now, sir. Or you're moving
No,
the
actually,
slide?
I'm on slide number 7.
No, sir. It is not moving here.
Okay. I don't know what
Put
is
it
the
as
problem.
slideshow. Put it as slideshow, sir. Then.
It is in slideshow actually.
But
Let me just reshare the screen.
Yes, sir.
But the audio is audible, right? I mean,
yes, audio is audible, sir. Audio is not breaking.
Let me just reshare. I don't know what is the problem with this. So is this visible now, the slide?
Slide is visible, sir.
So I am basically on this slide number 7. I'm just putting it in slideshow mode. Now is it the full screen visible?
No, sir, it is not visible.
Is it visible like this?
Full screen is not visible, sir.
I'm not sure what happened. Is it visible now, ma'am? The full screen?
It's not visible. Sir, the slideshow, you put that from current slide, sir. Go to slideshow and put from current slide.
It's slide number 7, actually. It's slide number 7. Can I just share it with you over the email? You can share the screen there?
Yeah, I can share the screen, sir.
Okay, I'll just share it over the email. I'm sharing it to Padmapriya, ma'am.
Yeah.
I don't know if it's a network issue or something. Yeah, I'll just share it across with you, ma'am, over the email.
Yes, sir.
I'll just try one last option and see if it is visible to you. Is it visible now?
Yes, sir, it's visible now.
Okay, great. So I'm on slide number 7.
Yes,
so I'm extremely sorry for the technical glitches. I don't know what is the problem. Is it my laptop or is it the Teams Zoom that is creating an issue? But anyways, so let us move forward. Basically, I was mentioning that invention, basically as per the Patent Act or as per the patent law, needs to have these 3 basic requirements, and only then it is referred to as an invention. So first and foremost criteria is that it should be a new product or process. It should involve an inventive step, and it should be capable of industrial application. Let us quickly touch base on the next slide. I'm on slide number 8. Hope it is visible to you. So basically, we are referring to the first criteria, that is called as novelty. So what does novelty mean is basically your invention should not be disclosed in any form, in any subject matter or in any possible publication before you file the patent application. In very simple term, as you can see the word state of art or prior to filing, basically this means that if you yourself publish an IEEE paper, if you yourself give it on your college's website or company's website that I am planning to file a patent application for the invention, this, and you provide the details accordingly, that means before filing of patent application itself, you are trying to disclose it to a public domain. That is what is the interpretation made by the government. So be it you yourself publish it, or be it any other party, be it your friend, or be it your other colleague in a college, or be it the faculty members of different department, publish it for publicity or for any reason whatsoever. If it is known to public by any form on internet or on books or any publications, it is considered as your invention is known before filing of a patent application. So this is the most concrete requirement for filing a patent application. And in our real-time experience, we have faced this difficulty with a lot of faculty members across India. I'm referring to, and a lot of reputed universities as well, including IITs and Manipal and Sikkim universities, wherein they are more interested to get a paper published before filing of a patent application. Unfortunately, the law says that if you want to publish your patent for this particular invention of yours, then it is recommended you file a patent application first and then publish it in any of the portals that is available. That will secure your publication or the rights of your patent application. But in case if you fail to do so, that means your invention is not considered as novel and you will not be eligible to get a patent granted for. So this is the most concrete requirement, not only in India, but anywhere across the globe. So one thumb rule for in case if you're interested to file a patent application for your invention, for your project, for your thesis, or any subject matter, do not publish it, do not disclose it in detail or in any form before the filing of a patent application. This is the first criteria that we were referring to. And this is what is referred to as a new. The new term new here indicates that your invention should not be known anywhere before filing of the application. Inventive step is the second criteria. As you can see in the image on the slide number 9 that I'm presenting right now, basically there is an evolution in the mobile phone technologies. Earlier, the phones were actually not even existing. We used to write it using those, the feather of this particular, pigeon or any other animal, or we used to write by using pen, and then we got evolved into a telephone, which is a landline phone. And now today landline phones are actually not even existing in most of the parts in countries or outside in the world. Everybody is trying to use a smartphone or a cordless phone which does not have a link or a line connected to as a restriction. This is evolution, and this is the evolution, the technology of mobile phone or the telephones. Now, this has close interrelation with the criteria that I am trying to share here as an inventive step. This is the second most required criteria of a filing of patent application. Basically, what it means that whenever you file a patent application or whenever it is an invention, it is expected that it should have some technological or technical advancement as compared to the existing knowledge. That means it should have some improvement, some efficiency increased, or some enhancement in the existing prior literature that you may have known here in the art. There should be some technological advancement as compared to the prior literature. That is the first sub criteria of this step. Second sub criteria is that it is an or kind. That means it should either have the technical advancement or it should have an economical significance. I will try to elaborate these things with an example, but economical significance here in this slide, it means that it should not be only associated with the cost, or it can be anything about space, it can be anything about the time, it can be about even cost for that matter of fact. And then most important criteria is it should not be obvious to a person skilled in art. Let me try to elaborate this definition with an example of an inventive step. Okay, now you see that the second image that you are seeing in this particular screen is about a landline phone. Now, we know that landline phones were really essential maybe 10 years back or maybe 15 years back, but they have a restriction. The most important restriction was that the first thing is they were always connected to a wire. They were not movable, they were not portable. And that is the reason when the phones, which were mobile phones, the name mobile itself indicates that you can carry it anywhere. As you're aware that you come from engineering background, mobile or portable devices are nothing but a device which can be carried from one place to other place. So when these phones came into market, which were not connected to a wire, it was really an essential need that was solved by these particular phones. You can carry it anywhere and you can call from those particular phones at any point of time, at any location. So as per the definition of inventive step, when a technical advancement is analyzed, the examiners of the patent office check whether there was some problem that was available in the existing literature or existing products for which you have come up with a solution to it. So like I mentioned, the problem with the existing landline phones was that they were not cordless. They were always connected to a cord. You cannot carry it forward at any place at any point of time. To solve this problem, the inventor or the applicant or the innovator came with a mind of a portable phone which is not connected to a wire. So that is the reason why there is a technical advancement over it. Economical significance, as it is in or, even though the mobile phones are costlier, since they have a technical advancement over the prior art, they are considered as having inventive step. And it is not obvious because earlier all the inventions known in the field of telephone, they were all associated with a wired phone or the cord based phones. So this is a non-obvious solution that is given by the inventor for the mobile phone or the smartphone. I'm sure the details of this particular criteria must have already discussed in the previous session, so I'm not going into much details of it. Third criteria is referred to as industrial applicability. It means that people should be capable of making it and using it. Whatever invention you are proposing, it should not be hypothetical or imaginary in nature. So people should be capable of making it and using it in the market or in the industry is what the third criteria mentions. Right. With this particular note, I wanted to quickly come back to the core mandate given to me for this session is about life cycle of a patent application. The slide which you are seeing currently is slide number 11, and basically this particular slide is about the life cycle of a patent application in a very user understandable format. This is not that simple as it is depicted in the slide, but I'll try to explain each and every point in a very clear manner with an example if required, and you'll be able to automatically appreciate what I'm trying to suggest here. The first and foremost criteria, like we discussed in the earlier slides, in case if you want to file a patent application, you need to have an invention. So patent is granted only for inventions. Okay. So if you have a concept, if you have an idea, that may not essentially be always an invention. Okay. When we say it is an invention is when it basically satisfies the above three criteria that we just discussed. Okay. When you have these particular details available with you in terms of what is your invention, what is new in that particular invention, how you plan to implement it, what all details are required for implementing that invention, uh, and whether it is possible to implement and use it in the market. When you have all those details available with you, that is the time when you file a patent application. The first most important step is called as drafting. So patent is not like a normal IEEE paper, or it is not like a normal journal paper, or it is not like a normal project thesis writing kind of material. Basically it has some criteria, or it has some procedure that needs to be followed when we draft application. Any person can draft it. There is no requirement of having a very techno legal expert for drafting an application. But what happens is, like, when you write a patent application in a manner that is required to a patent office or mentioned in the patent act, that will help you to easily convey your information, as well as help to get through the patent granted for it. Sometimes what happen is, like, the applicant or the inventors are very essential, very crucial to write their own invention, which is very well appreciated, but the problem is that they fail to comply with some of the requirements of the patent office or the patent act, and eventually, being a good invention, in spite of being a good invention, they end up not getting a patent granted for it. So I'm sure the next presenters will definitely go into details of each and every requirement, or it must have already been studied in the previous sessions. But I will also try to touch base in the next slides what are the requirements for drafting an application. Now, what happens when this application is drafted? It can be drafted in a A4 size paper on your computer. It is not mandatory that you need to have a legal or a stamp paper based kind of documentation. You can just write it on a A4 size normal Word document. Once it is ready, you can file the application at the patent office. Now, there are two types of applications that can be filed at the patent office. When you have a concept or idea in your mind and you are not sure at the moment that what are the implementation details or how I am going to implement that thing, but I'm aware that this invention really has a potential and it is really a good invention and a unique one, you can go and file a provisional application at the patent office. This provisional application will not only safeguard your idea or concept, but also give you a date. This date is referred to as a priority date, which indicates that any person whosoever filed the patent application after this date will not be eligible to get a grant of a patent at this particular patent office. Okay. So this is in other words, you can call it as it's a temporary application. Provisional application is a temporary application, and this, along with this date, government gives you a 12-month of time for filing a complete application. Now, what is the difference between provisional application and complete application is that provisional application, like I mentioned, it will cover only the concept or idea. But ideas or concepts are not patentable because the earlier definition says that your invention should have all the details about those particular three criteria. So in order to fulfill that requirement in terms of providing all the details about your implementation possibilities, this 12 months of time is given by the government. Okay. Now, when the complete application is filed, that application is referred, as the name indicates, complete application, and this application goes through the further processing, which is visible in this particular slide. When a provisional application is filed and you fail to provide the details in terms of complete application within those 12 months of time, the application does not move forward for any of the steps which is visible after the filing of the application. Like I mentioned, let me reiterate, provisional application is neither published nor examined by the patent office. You need to, under any circumstances, if you want to get this particular case published or examined, you need to file a complete application. Now, the term I'm referring to is the government because to go into details, basically the patent office, which is a government office, is in India, it is referred to as Indian Patent Office, and there are 4 patent offices in India. So one is in Mumbai, other is in Delhi, third is in Kolkata, and fourth is in Chennai. So depending on the address of applicant, whosoever is applying for a patent, depending on the address, you can choose whichever office you want to file. For example, if a person is from Maharashtra, he is expected to file a patent application in Mumbai based on his jurisdictional address. Similarly, if a person is from Jammu Kashmir or from UP, he can file the application in Delhi. So similarly, the other parts of India is accordingly divided from the jurisdictional or the address of the applicant perspective for the ease of the applicant for processing this particular application. So whenever I'm referring to the government, it is always associated with the Indian Patent Office, IPO in short form, what is it referred to as. Now what happens is, like, after the application is filed, the application gets published on the Government of India, that is Patent Office site, after 18 months from the filing of the application. Now, this 18 months is a statutory time, that is the time given by the government or the Patent Act for publication of your application in free of cost. So any person who files a complete application, any person, without taking any efforts or pain, this application gets published after 18 months free of cost on the Government of India's, that is Patent Office website. However, there are many applicants who are in rush of getting that publication and sharing it with their colleges and sharing with the other parties who are interested to have a tie-up with them for implementation of the invention. So government gave them a second option of publication, which is called as early publication. So for example, instead of 18 months, if you file a early publication at any point before the 18 months of time period, that is the free of cost time period given by the government, you will be able to publish your application within 1 month from making such request. Okay, this is very important to understand. For publication, there are 2 options. One option is the free of cost option, which is after 18 months, automatically the application gets published. Second option is early publication, wherein you need to pay some nominal fees to the patent office, and they will publish your application within 1 month of time from making such request. Third important step in the life cycle of a patent application is called as request for examination. The box which shows pre-grant apposition in yellow color, you can ignore this at the moment because this may not be crucial from understanding the life cycle of patent application. But a normal course of a life cycle goes in this manner. So after publication, you need to file compulsory a request for examination. Now, it is not mandatory that you need to file it only after the publication. You can even file this request for examination even before the publication of the application or along with the filing of the complete application itself. What is the cruciality is that unless and otherwise you file this request for examination at the patent office, the examiners or the patent office will not take your application for examination. That is, when I say examination, basically it is to check whether these 3 criteria are met by this patent application or not. They will not scrutinize or they will not check whether your application has invention or not. So this is very crucial to understand. So request for examination is mandatory. Here also, recently government has given you various options for examination. The first option is called as request for normal examination, wherein the patent office will accept your application for examination, and they will take around 1.5 year or 2 years maximum for examination of your application after making the request. What happens basically in the examination process is that a person from the Government of India Patent Office is allocated for your case. Now this person is a technical person from that field of technology, whichever your application belongs to. Okay, so this person reads your application, and based on that reading, he make an understanding of the invention. He checks whether your invention is understandable, whether your invention has those requirements satisfied about what is the invention and how it is possible to implement that invention. And if he feels that all the three criteria that we discussed in slides a couple of minutes back, if he feels that yes, these have all the requirements satisfied, then he will issue a patent, that is he will grant a patent for it. Okay, so this checking is done only after the request for examination is filed, and without that request for examination, it is not checked. In a normal examination request, this process takes around 1.5 years or maximum 2 years, like I suggested. Government has given you another option called as expedited examination, according to which your application, if you make a request under expedited examination, your application will be considered for examination within 3 to 6 months of time after making or upon making such request for expedited examination, and the same process will follow through. So there is a substantial less time required for expedited examination as compared to the normal examination. Obviously, the fees associated with that is differing, and which we will discuss in the next slides, a couple of slides. So what happens, like I mentioned, after filing the request for examination is that examiner is allocated and he reviews your application. Now, obviously, if there is no concern from the examiner side in understanding the invention, in understanding the novelty, inventive step, and industrial applicability of your invention, he will issue a patent, he will grant you a patent. But in case if the examiner has any queries or any concerns about your invention, for example, it may be a possibility that the examiner may not understand the invention clearly, or you may not have disclosed the invention to an extent that it is understandable by the reader. Okay, so in that case, the examiner issues an FER. FER is nothing but a first examination report. Now, this examination report is not a rejection. Basically, it is an analysis made by the examiner at the patent office in terms of what queries he has observed while reading the application, while reviewing your application. So in very layman term, if you compare this life cycle with an IEEE paper that you may have submitted in the past, this issue of FER is nothing but the peer review or the review process that happens in the IEEE paper. So the reviewer gives his comments in terms of what he feels are the lacking parts or lacking features of your paper, and you need to resolve that issues and resubmit this particular paper. However, the only difference between this process and the patent process is that here you need to prepare a reply in terms of that may be explaining each and every queries or concerns that the examiner may have about your application in view of the FER, or you may try to amend or revise the claims or the description within certain limits to overcome these particular objections. So this is what is the part of issue of FER and then replying to that particular comment to picture. Many times what happen is like, if you'll ask me, out of 100, around 80 to 90% of the time it happens that when the response or the reply is filed to the queries explaining the invention against the objection, the patent gets accepted. The examiners will have clear idea about what your invention is and how it will resolve its queries. But many times it may be a possibility that even after submitting the response, the invention is still not clear. One of the most important part that generally happens is that there are many literatures that are available in the prior art before you file a patent application. So many times it happens that the examiner failed to understand where exactly the technical advancement part of your invention comes into picture. So that is the reason in the FER they cite couple of literatures that may be IEEE paper, that may be any non-patent literature, or it may be a patent literature, that is the patent application filed anywhere across the globe. So they can consider those literature obviously from before the date of filing of this application, and they say that since this was publicly available before the filing of your application, please let us know what are the technical advancement over these literatures from your inventions perspective. So these are very common queries that we see in the FER, and when we reply, we need to clearly highlight those particular points where the examiner finds it difficult to understand the invention. So once you do that, obviously the patent is granted. However, if even after submission of the response, if the invention is not clear to the examiner, there is a final option called as hearing that is given by the patent office. This hearing basically is a face-to-face discussion with the examiner at the patent office or the controller at the patent office. And based on this discussion, his queries is expected to be resolved during that discussion. And generally nowadays it is happening through video conferencing, but 2 or 3 years back, it used to happen physically at the patent offices. So patent office on daily basis is trying to reduce the burden of the applicants by bringing in very new processes and trying to, turn or incline in favor of the applicants to issue or to grant the patent application as soon as possible. So once this hearing is done, the fate of the application is decided. That is the last, second last, the box that you can see. Either the patent is granted or it is abandoned or it is rejected. So this is what is the overall normal life cycle of a patent application. Okay, I'm sure there must be some queries and we can take those queries at the end of the session. In case if required, you may please post your queries in the chat box as well, and I can take those queries at the end of the session. So this is what is the overall process. Please let me know if in case if anything is not clear, and we can repeat after the end of the session. Like I was mentioning, in the first or the second step, when the invention is certain that this is the invention, a drafting of the application has to be done. Now, when we draft the application, these are the tabs, or these are the headings, and the contents of this particular heading are expected by the patent office. You may have noted that there is certain correlance in basically the IEEE paper, or the research paper or the journal papers that you submit at publications. So title of your invention has to be there, field, in which field of technology this invention belongs to, that has to be clearly written. Background information of the invention, that means in the paper form, a prior art literature or a prior literature has to be written in this particular format. A brief summary of your invention, in an IEEE paper format, it is referred to as an introduction of the invention. Then a brief description about your invention has to be given, that is a proposal. A detailed description in terms of how you propose to implement it, what are the possible implementations, what are the examples, comparative analysis, comparative charts, everything can be given in this detailed invention. A claim is basically something which is the core part of your invention in terms of what you feel is an advancement over this particular invention, is basically covered in the claim section. Abstract of the disclosure is a brief summary of your invention, and the drawings, obviously the drawings has to be given in a prescribed format, and you can submit those drawings in this particular patent office. Okay, this is what is the format that is expected by the patent office when you file a patent application for it. So in case if any of the fields is missing during the examination, which is around, I think, 1, 2, 3, and 4th, last 4th step, you would see that during the request for examination is made, these things are checked whether this is in order or not, whether the information provided in these particular tabs are they as per the required or as per the prescribed requirements of the patent office or not. And you will be considered whether to give the objections, or whether a patent can be accepted for it. Now, by seeing this content of the draft, you would note that this is really not difficult. And frankly speaking, you won't require a very, expertise knowledge about this field of patenting. You as a technical writer can also write this particular document in your own terms. Most important is like you cannot, go beyond these particular fields. So you have to specifically stick to these particular point and only then provide the information in that particular document. It is not mandatory required that you need to hire an agent, patent agent like me, to write or draft the application. You can yourself do it, and many people across the globe are doing so. Okay. Having said that, I want to just introduce quickly with the fees, the government official fees required for filing of a patent application. This slide is a very brief picture of the mandatory steps that we just discussed in the flowchart. So basically, the first step is filing of a patent applications. Once the patent draft, or once the draft is ready at your end, once this document is ready at your end, when you file a patent application in the name of individual or natural person. Now, when I say individual or a natural person, that means it should not involve any entity or a company or a college. If it is filed in the individual, for example, Swapnil Sanab, and there are around 100 other inventors whose name I want to include in the application, you can do that. They will still be considered as an individual. Or if you have a company which is registered under Make in India or a Startup India concept, it is having a startup certificate according to those particular mandates. Or if your company is a small scale or a medium scale entity under the MSME Act, the official government fees is only 1600 rupees. That is the government fee that I'm referring to. Or if your company is a large entity, for example, companies like Tata, companies like Infosys, companies like Wipro, these are all having a financial turnover of more than 50 100 crores. So those companies are recorded as large entity as per the MSME Act. And any college or any institution is also, which is not a part of a government aided institution or a part of government subsidiary, they are considered under the large entity as per the act, and the official government fees is 8,000 rupees for them. That is the filing fees for that is the first step. As you can see in this particular chart, filing of an application with complete or provisional specification, this is a step where this fees in the first point comes into picture. Like I said, in the second step of this particular chart, where the publication of the application is written, if you wait for 18 months, your application gets published automatically on the Government of India's site website. Okay, but in case if you want to opt for early publication, then you can pay a nominal fees of INR 2500 if you are an individual or a startup or a small or medium entity under MSME, and you can get your application published in 1 month of time after making such request. The most important criteria here is like your application should have not crossed 18 months of time period for applying for the early publication. Why? Because if it has already crossed 18 months, then patent office will automatically publish your application free of cost. You don't have to pay this 2,500 rupees for them. But if it has not been 18 months, even if it is the 17th month, you can file this particular request and get your application published. Similar to the first step, if your applicant is a company or a college or an institution, the government fees for filing this particular early publication is 12,500 rupees. Okay, this is the second important step. Now, according to the flowchart, the third and most important step, like I mentioned, it is request for examination. Now, this request has to be made mandatorily, and if you don't make that request, your application will not be considered for examination and it will go fail. It will go abandoned. Okay. Now, in order to file this request for examination, I mentioned there are two options. One is a normal examination and other is a expedited examination. The fees for normal examination are lower as compared to the large entity. For example, as compared to the expedited examination, sorry. So normal examination, when you opt for, the only difference between normal and expedited examination is that normal examination takes comparatively more time for examination and issuance of a patent. However, if you file an expedited examination, the time required is substantially low. And this has recently started, preferably, if I'm not wrong, it has started in 2016 March, that this initiative has taken by the Government of India, that an expedited examination option can be opted for. So normal examination for an individual or a startup or a small or medium entity under MSME Act, it costs you INR 4,000 rupees. And if you are a company which is a large entity or a college or institution, it will cost you 20,000 rupees. Similarly, if you file an expedited examination instead of normal examination, the fees for filing that is for an individual, a startup, small entity or a medium entity is INR 8,000 rupees. However, if you are a company and if you are a college or institution, normally you cannot opt for it, but if you want to opt for it, the fees of INR 60,000 is applicable for expediting the examination. Any normal entity which is a large entity cannot opt for expedited examination unless and otherwise it satisfies few of the other criteria. I do not want to go into it, but there must be some other session scheduled for it for the criteria. To avoid the confusion, at the moment you can just note that a college or an institution or a large entity like Tata or Infosys cannot apply for expedited examination under normal circumstances in India. They have to either file a PCT application or they cannot opt for this particular thing. This slide at the bottom shares basically a link for this particular fees from the Government of India portal, and you note that these are only the exemplary fees that are required in the life cycle of patent application. Once the patent is granted, a yearly annuity fees or a maintenance fee has to be paid at the patent office, which may not be substantially high, very nominal fees. For example, 800 per year for first 4 years. So such fees has to be paid, and that fees can be seen or visible in this particular PDF document for you. You may have noted the fees. For example, if it is an individual, startup, or small entity or medium entity, the first three tabs require only 8,100 rupees fee for the overall patent life cycle processing. For example, till the grant of a patent. So from the filing of a patent application till the grant of a patent, the government fees required if you are an individual, startup, medium entity, or small entity is only 8,100 under normal examination process. If you opt for expedited examination, the fees is 12,100 rupees for an individual, startup, or medium entity. So which is way cheaper as compared to publishing your IEEE paper in any reputed journal. For example, if you want to publish your IEEE paper in elsewhere journal, if I'm not wrong, please correct me, minimum of 15 to 20,000 rupees are required for just publication of your paper in those particular journal. And what is the value that you get as output? Frankly speaking, based on the paper, you cannot enforce your legal rights on any of the person who is copying your invention from that paper. But patent, in much cheaper rates or fees, it gives you that legal right for enforcing your legal rights at any point of time in a particular jurisdiction if you find that somebody is copying your invention, right? So of course, each of these IEEE paper and patent application have their own advantages and disadvantages. I was just trying to mention that from the legal or the law perspective, patent filing holds more higher standard as compared to the IEEE paper from the perspective of the patent laws, because your paper, using your paper, you cannot stop anybody from copying it or using it or selling it. Let me try to explain this with an example. Okay, I have come up with an invention where my car runs on a water. Okay, this is a very good invention because that is the immediate dire need of the current market, because petrol, diesel, and all other fuel rates are increasing substantially high, and a normal person or any person cannot afford those particular higher stakes or higher rates at the moment. So what I have done is, like, after years of R&D, I have come up with an engine or a car which runs on a water, and it is eligible to go and work in a very normal form as the normal car works. But what I did is, like, instead of filing a patent, I published this particular invention or its working in an IEEE paper. Now, what is the impact of that is that the big reputed companies, automobile companies, noted that this person has already filed an IEEE paper which is published in the market, and without his permission, without his knowledge, they start manufacturing the product and selling it in the market. So one fine day, you go to buy a car and you see that this car works on water, which is my own invention couple of years back. So what is the solution available with you? You go to that particular company or the manufacturer, you tell them, boss, this is my IEEE paper, I have already published this. They will say, sir, you do not have any legal right. This is just a paper publication. You cannot stop us based on this publication. So the summary of this particular example is that in case if you require a legal right, patent filing is only the option for securing the rights of your invention. In contrast to this example, if I would have filed a patent application for that invention as and when that idea come in my mind about the implementation, along with all the results and how the details of the engines are, and then I would have gone for publication or contacting any of the automobile manufacturers, that would have given a better security, better results as compared to just publishing it in the journal or paper or any conference and all those things. This is the impact of filing a patent application. So what my humble submission here is that instead of focusing on publication of a paper, if you really feel that your idea has a potential to make a difference as compared to the existing technologies or existing solutions, please don't even think twice. Just go and file a patent application for it using these particular details and following this particular process. I will try to give a very simple example also for you. So, the cars, Mahindra cars, and I have seen it in Mahindra cars only at the moment. Mahindra XUV 500. Basically, what happens in them is like the car air pressure is automatically detected by the car, ETU or the electronic trip unit, and it gives an information that this particular part or this particular wheel of your car has less air as compared to the other wheels. Now, impact of this is that in terms of driving, it will consume more petrol, and it will give you less average when the air pressure or the air is less in any of the tires. Now, earlier stages, you have to check it manually whether the air is sufficient or not in the tires. But here, the Mahindra XUV has come up with this particular solution, kind of patent application, wherein you can automatically get an update about your air pressure in the vehicle, and then based on that, you can take necessary actions, whether it is really punctured or whether it is essential to fill the air in it, which will not only help to save the petrol, but also from a long run perspective, it will help you to drive safely also. Same goes for the petrol also. So Mahindra have this mechanism wherein it automatically detects the amount of petrol present in your tank, and then based on that, it gives you how much this particular vehicle, based on current parameters, can take you to a distance of kilometers. So these are inventions which came to a normal person when facing the real-time problems. You and I are nobody different. We are also normal people. Any problem that we see in the real-time environment, real-time scenario, and if you try to provide a solution to it, that is definitely going to help you get a patent granted for it, because these are all real-time problems that we face, right? So these are some of the examples where a patent can be granted. I've just given an example of Mahindra. There are so many good examples that are available. Tata Nano. You won't believe Tata Nano has almost around 250 patents just for each and every part of this particular vehicle. Be it a design patent or be it a utility patent, even the screws that they have used in this vehicle, they have been patented for that particular technology as well. What are the requirements for filing a patent application? Like I mentioned, a draft has these requirements. So for example, the second tab of this particular slide, you would see that drafting is required, which needs to have these particular fields in that particular document. However, when a patent application is to be filed, what are the required essential things when we file a patent application for it? The first most important is that we need to submit full address, nationality, and name of each and every applicant and inventor of this particular application. What is the difference between applicant and inventor is that inventor is a person in whose mind this particular idea has come in for the first time, whereas the applicant can be even that inventor, or he can be or she can be anybody who is assisting that particular inventor in terms of financial aid, or in terms of an employment, or in terms of payment for R&D and everything. So to give you an example, if I am working in a reputed company and they're paying me an amount of XYZ for researching on a particular domain of technology, then I will be the inventor if a patent application is filed for my invention, and the company who is paying me for doing this research work will be the applicant of this particular invention. Ultimately, the legal rights or the rights of this patent application belongs to the applicant, and inventors are maybe for credit purpose, you can say. Okay. Second important part is that you need to file a complete specification, claims, and abstract. That is, this particular content is to be filed in Form 2. These all forms are available on the Indian Patent Office website. Even you can just Google and see those forms for filing a patent application in India. You'll be able to see all those forms there on internet also. There is a public access to this particular links. So once this document is filed at Form 2, the third point, power of attorney is required in case if you file this application through a law firm or a patent agent like me. If you need an assistance and if you want to file those applications, then you have to give an authority to that particular person that you are allowed to file this application on behalf of us. So Form 26, which is referred to as power of attorney, is required for those particular authorities. Fourth important part is filing of a Form 1. This Form 1 indirectly acts as an assignment. Assignment means that all the inventors have given their rights to a patent applicant for filing this patent application. So indirectly, all the legal rights are transferred to the applicant by way of this, by virtue of this particular form 1. Okay. Fifth most important part is form 5, wherein you indirectly or directly submit the consent that all these inventors whosoever name is included in the form 1 are basically the true and the first inventors as far as your knowledge is concerned, and there are no other inventors. So you submit this form 5 for that particular purpose. And form 3, if you have filed the application anywhere outside India before or after the filing of a patent in India, you need to submit that information in this particular form. So all these forms are really essential forms required when you file the application at the patent office, Indian Patent Office. Form 26 is required only when you file the patent application through an agent, or if you file it through any agency. But if it is filed by your own self, then there is this form 26 not at all required for filing this. Okay, so these are basically some of the points that I wanted to discuss based on the time allotted to me. I think I already wrapped it a bit early, so I'll be open for questions if any after this particular slide. Hello.
Hello, sir.
Yes.
Yes, sir.
I think I have pretty early. I have just wrapped it a bit early because the the time and the topics those were given were only from the perspective of publication and examination. So I did not go into details of it.
Okay, sir. Okay, sir.
Sure. So
Okay.
I think I already started receiving the questions in the
Yes,
what do you
sir.
say, the chat box. So I'll start replying to them, and then I'll take some real time questions as well.
Yes, sir.
So
Yes, sir.
yes.
Patents can
I
be.
think I have, yes, Dr. Gupta has shared a question with us. So according to him, the comparison with journal is not relevant because to get patent in is time consuming process, whereas for journal, it's a matter of 2 to 3 months. In academic time, it's important factor. So we all go for journal. Sir, absolutely, I agree on your part. I totally appreciate the perspective as well. Just few of the points based on my experience with the patent office. Like I was mentioning, after 2016, the patent office has started the option of expedited examination. According to this expedited examination, we have seen patent getting granted in 91 days. So that is the reason why expedited examination was brought into picture, sir. So when you file an expedited examination, the patent office have a separate queue of examining this patent application. So whenever that request is made within next 3 to 6 months of time, that is a normal time period given by the patent office, your application will be examined, and if it is eligible for grant, it will be granted. Our firm or myself have worked on few of the pharmaceutical patents wherein the patent was granted in 91 days. I think this is not even granted in so less duration of time in countries like United States or Europe, for that matter. So I slightly differ on this particular suggestion that journal is must. The second problem that happens when a journal paper is published and a patent is filed, like I mentioned with an example, why to file a patent application? That should be a question asked. If you do not file a patent application and if you just publish your paper, IEEE paper, from the academician's perspective, you will not get any legal right for that particular paper publication. You will just get a copyright for that particular paper. You won't be able to enforce if your invention is copied from that particular paper to any company who is copying it without your permission, right? So this is what is the biggest difference between a journal paper, IEEE paper, and the patent. So obviously my intention here is not to compromise or jeopardize the existence of an IEEE paper. My only humble submission here is that what is the difference between the IEEE paper, instead of just filing it and getting a publication on it, and filing a patent and then getting a patent application granted for it? Legal right is the thin line of difference between them, whether you get a legal right or not. I'll try to give a simple example what I'm referring to a legal right here. When I buy a particular house, I'm just giving it from a real-time experience, okay? When I buy a particular house or a flat in any building, what happens is like I get those registration documents under my name. So this is what is a legal right of that flat given to me. This is what is referred to as legal rights in the law term. If I do not get those registration documents, tomorrow anybody, for example, the builder can come and say, boss, this flat does not belong to you. You just go out and that's it. You cannot legally prove anything if you do not have those documentations. Similarly, if I have a journal paper and if somebody copies my invention, big companies, big corporate, big bullies, I cannot stop them if I don't have any documentation to it. So I hope, sir, I was able to answer your specific query. Of course, there is no comparison because they all have different mandates in itself. If I'm not wrong, the journal papers are required as a mandate for PhD holders and for research scholars to be published from the academicians or the college perspective. But from legal rights perspective, from the patent laws perspective, IEEE paper really does not have that legal value from this particular enforceability perspective. The next question I got is from Mr. Bhuvanesh Kumar, sorry. The patent can also be published within a month by filing fast publication fee. Now you can say it is faster than publication. Absolutely, sir. Like I was mentioning, the fees of 2,500 rupees, you don't have to wait for 18 months of time period. You can even publish it in 1 month by making that request for early publication. Publication has no value until grant. I think Dr. Gupta has again commented on that part. Everything has a value, sir. Patent is basically a field of law. So what happens, what is the impact or what is the importance of publication is that the importance of publication happens, or as and when it starts, the patent gets published. That means people in market anywhere sitting across the globe come to know that this person, this particular college or this particular company has filed a patent application in Indian Patent Office. If they try to copy it, if they try to manufacture a product out of it, if they try to use your invention without your permission, and as and when your patent gets granted, be it 1 year later, be it 91 days later, be it 4 years later, or be it 10 years later, if you are aware that after the publication that XYZ person has started using or copying your invention from the date of publication till the date you decide to sue him or to file a case against him, you can claim the damages, you can claim the revenue generated as per your will based on this particular publication's date. And that is the reason why publication is very important. So I again slightly beg to differ your statement that publication has no value until the grant. Yes, indirectly it is correct, but publication has its own value. Okay. Okay, I think Bhuvanesh, Bhavesh Kumarji has already replied to that. Great. What is the significance of publication of application? I have just replied to that to Mr. Ravi Prasad as well. Can I incorporate or remove the inventor name during complete application through their names? Yeah, though their names are there in the provisional application. Dr. Barun Kumar has this particular question. Very good question, sir. I really appreciate the perspective. Yes, the answer is yes. As per the law, as per the patent law, you can add or remove the name of the inventor or even the applicants for that matter from the complete application at any point of time during the life cycle of patent application. But it is more easier if you do it before the grant of a patent. There is a simple procedure. You can file a form 13, which is called as voluntary amendment or the correction in the name and address of the applicant and inventor, and you can be eligible for adding or removing this particular inventor name. Obviously, the patent office will ask you these valid reasons in terms of why you are removing this name and why you are adding these names. But it is always recommended that along with this particular form 13, you file a no objection certificate, which will signify that the other inventors, whosoever name is there, they have no objection on removal or addition of the name of the new inventor or deletion thereof. I hope I answered your question, Dr. Barun. Okay, is there any chance to file a patent on the topic which I already published few months before? So I think Sudhakar ji has this valid question. Sir, unfortunately in India the law is very clear that if you have published your paper and it is available publicly for public access, which is easily available on internet, unfortunately you cannot file. You can file a patent, but then during the examination it will be rejected. So it's recommended that you do not file a patent application for the published contents as it is, So you can modify it, you can work on it, you can find some improvements in those particular technology or the proposals and then file a patent for it. Just for clarity, to specifically answer your questions, even a 0.1% or even a 1% change or 1% improvement in the existing published idea can be eligible for filing a patent application. So there is no restriction that it needs to be completely 100% new idea. It can even be a slight modification to the existing literature, existing publication, be it your or be it others. And if it has that substantial improvement because of that modification, you can definitely get a patent granted for it. Okay, so let me see the next question. Okay, so I think Bhavesh Kumarji has another question. We have obtained design registration, then filed product innovation patent, and finally published research article. And will it create a novelty issue during the product innovation examination? So if you have filed a patent application before the publication, then there will be no issues as such. Just for clarity, if you have design registration obtained already, and those designs are as it is included in the innovation patent, or let us say utility patent. Uh, Bhaviji, just for clarity, product innovation patent, I hope it is not an Australian innovation patent. It is, if you are referring to the Indian utility patent, there will be no issues as such. But obviously, the difference in design and utility patent is that you need to provide the details of each and every working of the invention, and which is not present in the design registration. And you have already published the IEEE paper later than filing of these two patents. So I think there should be no issues, absolutely no issues on novelty for this particular invention. I think R. Murugan sir has a question that can we do patent for okay. Let me just see. I think I missed that question. Yeah, can we do a patent for equipment made by us but already published in articles? So I think that that is already answered. If it is already published and you are manufacturing or producing the same equipment as it is without doing any modification, that will create a problem, sir. So if you are doing even a slight improvement or slight enhancement, maybe in terms of working of that invention, or maybe in terms of the comparison from the perspective of workability of the product, you can definitely consider filing a patent application for it, sir. But as it is, if for example, if somebody is selling a product in United States, and you come up with the same product, you manufacture the same product as it is, unfortunately that will create a problem during the examination, sir. Apart from topic, I would like to ask one question. What thing or factor take you to IPR sector from your core sector? What is the scope to pharmacy postgraduates in IPR sector? So I think, sir, it's a very relevant question. My story is somewhat different. I sat in an in-campus placement through my college in 2010-11, and I got placed through this particular college in this particular company, wherein I was offered. It's a very funny story, but I don't regret that. So I was offered in an offer letter a job of software developer slash patent executive. And when we joined the company, they gave this yellow book in our hand indicating that study this act and you're going to work in the patent domain. So out of excitement, when we signed the offer letter, we did not bother to see there is the slash and there is a patent executive written. So along with me, there were 3 or 4 other colleagues. And so I just thought that it was challenging for me because there was a requirement of a technical expert in the field of patenting. So I definitely took an opportunity and pursued it further. And I think I'm still happily learning the new concepts in the field of IPR. So it has been really a very good journey till date. And I don't regret at all making that mistake of signing the offer letter. So I'm really enjoying it. So that's a funny story. Now to an important part, this IPR or the patent is a very important field of law, where technical experts from engineering domain as well as pharmacy, biotech, and life science domain are required. So I'll tell you again the story that we used to see back in 2008, 9, 10, where there was no much awareness of patenting laws to the faculty members or to the institution from that perspective. So I was not at all, or people like me were not at all aware of the IPR or the patent filing at that stage. So this field has a very good career for the students or even for the faculty members who are interested into research. Just to give you an information, I myself have around 25 publications in a reputed journal and around 30-40 publications in a non-reputed journals of IEEE paper. My core area of expertise is networking and ethical hacking. So I have been expert in the field of networking and DOS and DDoS attacks and hacking and other stuff. But I felt when I entered in this field, it was really challenging for me because I get to expand my knowledge scope by coming across various inventions, not only from the field of computer science, but from instrumentation, biotech, medical devices, and all those things. With regards to your specific query, pharmacy, whether they have good scope, yes, absolutely, they have very good scope. In fact, companies in Bangalore, Hyderabad, Delhi, Gurgaon, where there is a hub of pharmaceutical companies or research-based companies coming up with the pharmaceutical products, they require these people almost on a daily basis. If you can just check on LinkedIn or Google or internet, like requirement of a M pharma or B pharma in the field of patent law, you'll get thousands of jobs that are currently open in spite of having the COVID effect on the other jobs or other openings. This is a very open field for any newcomer who wants to learn the field of IPR. So I hope I was able to answer your specific question, sir. Uh, yes. So suppose after getting a patent, one does not pay renewal fees per year, then what will the fate of the patent? Whether limit of 20 years will stand valid or not? I think Dr. Gupta has asked another question to us. So absolutely, sir. Basically, the patent after the grant, if you do not pay the annuity fees or the maintenance fee, it goes in a lapse stage. So lapse stage is called as non-enforceable stage. So in order to keep the patent enforceable, like I mentioned, the nominal fees per year, for example, for second year to fourth year, every year the fees is 800 rupees. If you pay that 800 rupees every year till the fourth year, your patent would be maintained at the register of the patent office in Mumbai, and it is having the status or the legal status as enforceable. But unfortunately, if you fail to do so, then your patent would be in a lapse stage. So it will not be in an enforceable stage. Right. Mr. Kapil Joshi has another question to us. Can you suggest some basic tutorial based on patents? So, sir, the best option is the courses that are offered by WIPO. These are free of cost courses for any person to learn, understand, and if they want to explore the field of IPR. So there is this course DL 101 and 102. These are free of cost courses offered by WIPO. If you can just Google and see, you just have to enter your details, credentials, and do not have to pay any of the fees. This WIPO is basically a platform which is global platform basically, and it helps to spread awareness about the IPR in any person who is interested into learning the field of IPR. So from that perspective, this is a very good tutorial from the free of cost perspective. Otherwise, if you are looking for any workshop or any kind of what do you say, a kind of sessions that needs to be attended mandatorily, the Indian Patent Office at the Nagpur, they are also open for providing such sessions. You just need to check their calendar in terms of these workshops. They are nowadays providing it online workshop also. Earlier it was physical workshop, but nowadays they provide 3 to 4 days of training online, where the esteemed patent office examiners, controllers, also the faculty members or the fraternity from the field of IPR are the speakers there. They share their experience. They give you basic understanding of the requirements of the IPR and patent, and they help you to understand it in greater detail. You can just check on internet either the WIPO, WIPO DL courses or the Indian Patent Office courses, which are available with very nominal fees. For example, if I'm not wrong, for patent searching and understanding of basics of IPR, it is hardly 4,000 rupees for a week's session or something like that. So you can definitely explore that as well. Okay, so let me move on to the next question. Okay. Is it possible to change the title from provisional application to complete application? Dr. Barun has asked this question. Yes, it is pretty much possible. However, if you completely change it from the scratch, then it may create a problem. So for example, if your provisional invention has a title as a system and method for telecommunication, this is a provisional title, and if I while filing the complete application, I elaborate it saying that system and method for telecommunication between first device and the second device, that is pretty much acceptable and allowable. Irrespective of that, by way of filing form 13 voluntary amendment, you can change the title of your invention anytime before the grant of a patent application. So that again is a provision given by the government of India. However, condition is that it should not be something which is completely different, completely new, and beyond the scope of already filed applications. That is the mandate or thumb catch here. Okay, so I think Sudhakar ji has another question. If I have a patent publication after a few months or years, can I go for grant with new application for the same publication? Okay, so two questions in this, sir. If the patent is published and you want to apply for a request for examination, you can do it anytime within 48 months of the timeline from the date of filing of the application. Okay, so this is for a normal course, be it expedited or be it normal examination. The government has given you a timeline of 48 months, so you can file a request for examination within 48 months of time period. However, if I have understood your question correctly, the second scenario is that if you have published your patent application and you want to file a new application for the same publication, then unfortunately your own publication would be considered as a prior art for that new application. So you will not get a patent granted for the new application, sir. I hope I was able to give that particular answer. Sunil Gupta ji has another question for me. Patent form number 1 submitted electronically. Is it necessary to resubmit the form 1 with sign of all the applicants and scanned copy online? Frankly speaking, if you have already submitted the executed, that means the signed copy, electronically, there is no need to sign and submit again that particular thing. Provided that a blank form 1 is not accepted, you have to, after filing that form 1, at the time of filing, you will have to get the signature of the all inventors. Applicant signature normally is not required in the form 1. Only the signature of the inventors are required in form 1. So you can just scan that copy and submit it electronically, and the time period for that is 6 months from the date of filing of the application. Okay, so this is really mandatory. If you do not file it within 6 months of time, there will be a penalty or a petition fees required for doing that thing. So please file it if you have not filed it already. Scan it, sign the form 1 physically, not digitally. Okay, you have to take a printout of that particular form 1, sign it using there has to be a hand signature on that particular form, scan the copy and upload it at the patent office. That will help us to overcome those objections also in future. I have another question from Mr. Gokul. For expedited examination, which form number we need to submit? Okay, so for expedited examination, there is a form 18A. For normal examination, there is form 18. For expedited examination, it is form 18A. When you file a form 18A, you need to provide the details why you think you are eligible to file the expedited examination. One of the options for applying for expedited examination is that if there is a name of a women applicant in the list of applicants, then you can go and apply for this particular form 18A expedited examination. Or if your company is a small entity or a medium entity, you need to tick mark on that particular box, and then you can file an expedited thing. Or if you have filed a PCT application with India as a searching authority, then you can opt for this particular form. If unfortunately, if your applicant list does not have a women applicant, or you are not eligible under Startup India, then you may not be able to file a form 18A. This is very important to understand. Okay. As in case of journal publication, first and corresponding author gets more weightage. Is it same in the patent publication? Very good question. I think this question is from Dr. Soumya. So basically, ma'am, sir, the problem is that in patent, there is no such separate distribution of weightages. So equal rights are assigned to all the applicants. Like I mentioned during our session, is that inventors are mainly for credit purposes, or for the just to indicate who are the true and the first inventors whose mind this particular idea came into. Basically, all the rights or all the percentage share of this particular patent rights goes to the applicant. Whosoever name is there in applicant, be it one or be it multiple, equal rights are divided to those particular applicants. So unlike an IEEE paper wherein the first name is always given a first author and second and third are just, for example, credit purposes, there is nothing like that. Even if your number is at number 3, even if your name is at number 3 in the applicant list, you will be given the same rights as that of the first applicant. Gokulji has another question. While filing patent initially, can we pay request for examination patent? Absolutely, you can do that. There is no need to wait for publication of the application. You can file the request because it's a mandatory process. Publication is an optional process. Examination request giving is a mandatory process. So you can even file the request for examination along with the complete application. The only catch here, or the most important part here, is that your examination at the patent office will not happen until the publication of the application has happened. So if you wait for 18 months, and even if you have filed a request for examination or expedited examination at the time of filing, you have already lost 18 months of time. So if you are in rush of getting the examination faster in the patent office, what is recommended way is, along with filing of the application, you file a request for publication in Form 9. You, in 1 month, your application will be examined. It will be published. And along with that Form 9, you also file a request for examination, that is either a normal examination Form 18 or via expedited examination if you're eligible via Form 18A. And your application will be considered for examination immediately after the publication of the application. So you automatically end up saving a lot of time during the examination. Okay. I have another question. Can I apply a patent for my journal paper which I have published earlier? I think this has already been discussed. Unfortunately, for published literature, as it is, you cannot file a patent application. You need to show some improvement over that particular technology or that particular subject matter that you already filed. Yes, provided that if your paper is in an unpublished stage, you have just given it for review and it is not yet published, or only the abstract of that paper is available on the internet and not the whole paper, there are good chances that you can apply for the patent, because abstract is just a summary of this particular paper and not the whole details about the implementation. So you can still apply for a patent, and with the details of implementation or the working of the invention, you can definitely go for it. But if it is already published, then unfortunately there is a very less chance for it. Yes, I think I have another question from the same thing. As in the case of journal publication first, and this, okay, I think this is already covered. Okay. In the title, it consists of 20 words. Will it reject? Dr. Barun, there is no criteria of getting the patent rejected just because your title has 20 words. The mandate of the patent office is that it needs to have maximum up to 15 words about the invention, or about the summary or the brief information about the invention. Title should have 15 words. But if there is an objection during the FER, that during the examination, that your title has 20 words, you can delete some of the non-relevant words, or you can just replace that title with a relevant term with 15 words. So there is no criteria that if your title is having 20 words, it will be rejected altogether. So that will not be possible. It has not happened till in India till date. Okay. Are algorithms patentable? Very good question. Unfortunately, algorithms as such are not patent eligible. You need to show two things if you want to patent an algorithm. Firstly, thumb rule is that I will not use the word algorithm, because the act says that algorithm, computer program per se, or mathematical or business methods are not patentable according to Section 3K of the Patents Act. But each software patent that is generally filed are categorized under algorithms only. The only difference, there are two thumb rules, that when a software patent is filed or a computer related invention, be it embedded system or be it a hardcore software application, it is filed, there are two things that needs to be taken care of. One is, we should clearly try to show what technical advancement or technical advantages, technical benefits, technical effects this particular invention of yours is bringing in as compared to the prior art. And second is that you try to correlate or connect it to the hardware features or the structural limitations as much as possible. So for example, if my invention is about receiving data, so this is a normal algorithmic step, receive data or receiving data. But as and when I try to connect it with hardware, I will write as receiving from a first mobile device a data associated with something, that is a technical step. So this, when I connect this to a hardware, it automatically is eligible to provide or get away from the algorithm. So the best recommended way is these two options that I just suggested. And let me assure you, I have worked with so many telecommunication companies, including Ericsson, Huawei, Xiaomi, and Panasonic for that matter. And none of their patents, if I'm not wrong, out of 100, if you'll ask me, around 90 to 95% of their patents are categorized under software or Section 3K related invention. But that does not mean that these patent gets rejected. When we are able to show to the controller or the respected examiners that there is a technical advancement as compared to the prior art, there is some difference from the technical perspective that has been done, and when we connect it to a hardware, these patent gets granted easily in the patent office, Indian Patent Office. Dr. Bhumika has another question for me. We are going to patent publication. So initially we have to pay 20,000 or only filing fee. Uh, so 23,000, I don't know where this amount came from, but just for clarity, the government filing fees for a patent application, if you are an individual, is 1600 rupees. So 1600, and the fees for publication is 2500 rupees. Okay, so this fees of 2500 rupees is the government fees for individual or a natural person. That may be a group of individuals also. If you are a company, if you are a college, if the applicant is college, then the government fees for publication is 12,500 rupees. I think 23,000 is not a right value. I don't know where it came from. If you can elaborate on what you're referring to 23,000, that will help me to further clearly answer it. So Gokulji has final question for me. Is in a patent application, is inventor or applicant who has authority over the, like I mentioned, applicant is the true holder of a patent. Applicant gets all the legal right of a patent application. So applicant decides what is to be done with the patent application. If you want to sell it to anybody, if you want to license it to anybody, or if you want to do not do anything about the patent, it's the applicant. And inventors are merely for the credit purpose in the patent's perspective. Okay. Uh, Okay. Should patent be shown in experience section of a CV or resume, or separate header patents? I think Mr. Raghu has this question for me. Sir, it's totally up to you where you want to display it. But one thing I can clearly make you understand, because this is how, because I go for so many in-campus placements in Pune and Gujarat universities, and as a recruiter, what I see is like, what are the extracurricular activities apart from normal curriculum that candidate has done? So if I see that there are 50 people, and nowadays you know that every faculty is insisting on filing a journal paper and IEEE paper, I see it very common in most of the resumes. But when I see that there is a patent application filed and there is a patent number to it, I feel that this person is somewhat more dedicated and much more innovative, having an out-of-box thinking for that particular matter. And obviously that highlights your resume. So if you feel that separating it from the normal extracurricular activities, that will give a separate attention to the recruiter or the the reviewer, you should definitely do that. And I personally feel that it should be considered separately, because even when you see the profiles of your faculty members of your institution, you see that there is a separate field for paper publications, and there is a separate field for patent applications filed in India or abroad. In fact, if I'm not wrong, most of during the appraisals also for the faculty members, because that happens in Pune University, during the appraisals also, an IEEE paper publication has given a separate weightage, and filing a patent application has given a separate weightage. That is applicable even for NAC accreditation and other accreditations that are available by AICTE. I hope I was able to answer those questions. Okay. I have heard from someone that government academic institute is considered to pay individual fees for filing. Is it true? Yes, sir. In the recent amendments that has been done, frankly speaking, that is still in proposal. That is not yet implemented as such. For example, if I'm not wrong about the date, in January or February 2021, the government has given a proposal to include all the government aided or government funded institutions or colleges or companies for that matter for the fees reduction and categorized under individuals. But at the moment, sir, it is not yet implemented. So the act has not been revised. So it is still in proposal stage at the moment. But it is true, yes, they are planning to do that. Great. So I think that's the end of the questions. Any other questions? I'm open for new questions. Okay, I have one last question. If we break down the algorithm into series of mathematical steps, can it be patentable? Ma'am, when we say mathematical steps, basically that includes formula. And formulas as such is not patent eligible. But yes, if you are using formula in one of the steps for achieving the advancement over the prior art, here again the same logic applies. You need to show the advancement or the improvement over the prior art, and it should be connected to a hardware. For example, if you're talking about, I'll just give specific examples which are very well encouraged by the patent office. So if you're using an encryption decryption algorithms for achieving a better results, they are pretty much welcomed by the patent office. And even if their algorithms indirectly they are considered patent eligible. Same goes for image processing or data processing, or audio video processing kind of inventions, wherein obviously whenever we talk about processing or encryption decryption, the formulas are the integral part of those algorithms. So yes, absolutely, that uh, it is pretty much allowed to break down this particular method into multiple steps, and it can also incorporate the formulas, provided that two criteria that I just mentioned: improvement and hardware connection. Okay, I have heard that once a patent is granted, if there is no utility, then it is cancelled. Is it true? Uh, to an extent, it is true. So for example, if I get a patent, basically patent is granted for two reasons by the government. One is it only gives you a right to prohibit others from copying it, in a very layman term. And second is that you should be able to take advantage of that patent by utility or by utilizing it, and mainly for the benefits of the public or people in India. Now, if you are not able to satisfy that criteria, patent office understanding is that, then what is the purpose of that patent? So what patent office has, one of the requirements is that after the patent is granted, you need to file a form 27, which is a statement and working of the invention, in which you have to clearly indicate that uh, whether you have started implementing or working or selling the product of this particular patent or not. And they do not take any adverse action if you write that no, I haven't started working on it, because there may be various reasons. But if your invention is really having that potential, and if somebody wants to use it and you are not allowing them to use it, that person, whosoever wants to use it, can file an kind of revocation for your patent, and it is one of the grounds for revocation. Revocation in simple terms means cancellation. So that third party can file a cancellation request indicating that I want to use the invention for the benefit of public, but this applicant is not allowing me to use it. So that is the stage where the patent can get cancelled if you are not using or selling that particular product in the Indian market. But automatically it does not happen. Even if you file Form 27 every year indicating that no, I have not started using it, they will not automatically, patent office will not automatically revoke your patent application. I hope I was able to answer the question. Any other questions? Any other queries? It's really great to see so many questions coming up. I'm sure that I'll be seeing more and more patents from the colleagues here. So I think there are no more questions. So,
Yes,
ma'am,
sir.
I think we should wrap the session, or you have any specific points that I wanted to repeat?
No, sir, nothing. So I'll ask will mail ID and number they're asking, sir. I'll just
Sure,
post
I'll
in
just
LinkedIn.
share it.
Yeah.
Yeah, absolutely. So it is. I'm just sharing the slide. It's there. The number and the details are there. I'll just share that slide as well. Is the slide visible?
Yes, sir.
So my number and my mail ID is here.
So kindly make
So
it enlarged, sir. It's small.
is it visible now?
Yes, sir. Yes, sir. It's visible.
Sure. Great. So any queries you can write back to me. You can. That's my WhatsApp number. You can WhatsApp me for any assistance. I'll be very glad to help you in your queries.
Thank you, sir. Thank you.
Great.
So we'll have a group photo, sir. So
So you want me to switch on the camera? Okay, I'll just do that.
yes, sir. Switch off your participants. Kindly switch on your cameras. Yes. I think everyone switch on their cameras. Yes. Okay. Remind. Yeah. Thank you, sir. Thank you very much.
Ma'am, please also share these screenshots with us, so it will be help us
Yes,
for the
sir.
record purposes.
Yes, sir. Yes, sir.
Great.
I'll share you, sir. I'll share you the
Thank you so
recordings.
much, ma'am, and I think I should wrap the session then.
Okay, sir. Okay,
Sure,
sir.
great.
Thank you, sir. Thank you very
Thank
much.
you so much for inviting me, and it was really a great pleasure for being a part of this wonderful session. I really liked the question answer session a lot. Thank you.
Yes, sir.
I'm
Thank you
just
very much,
logging
sir.
off then.
Yes, sir. Thank you, sir. Thank you very much, sir. Participants, you can join the session by 12, sharp by 12. Okay. Sharp by 12 o'clock, we'll be having the next session. So, sharp by 12 o'clock, the next session. Yeah. Thank you, sir.